folks. This is Anthony Ania of Ania, Scanlon, and Serignano. Hope everybody's doing okay and surviving this COVID-19 pandemic. Obviously, we're all dealing with something we've never dealt with before in our lives, something that's completely different. We've all dealt with illnesses and situations like 9/11, but I think this is all in a category of its own and something that truly is unprecedented and wholly unexpected from a planning perspective. So what I'm going to do today is I'm going to talk to you about 5 things that you can do right now to help protect your assets and your life savings in the event something happens to you. And obviously, these are documents that you could have in place at any time, and most of you should have them in place now. But what I'm going to do is focus on what I think are really the truly most important documents. And these are documents that I've actually been touting and talking about for almost 35 years now. If you followed our practices at Ania, Scanlon, and Serignano, and if you followed, my articles and speeches, you'll see that most of the things that I'm going to tell you about today are things that I've talked about, as I said, for over the last 35 years. So let's talk about what I consider the most important planning document or advance directive that any one of us can execute. And that document is a durable power of attorney. So what is a durable power of attorney? A durable power of attorney is a form, it's a power of attorney that is durable. And what does that mean? It means that the power of attorney survives your subsequent incapacity or disability. So if something happens to you the day after you sign the power of attorney, that power of attorney is still effective. So it's durable and it survives your subsequent incapacity or disability. In addition, the power of attorney relates to financial matters. This is under law, under the General Obligations Law of New York. It's a document that allows you to appoint what's called an agent, someone that can transact financial affairs for you if you're no longer able to transact them. So the power of attorney is actually effective the moment you sign it. You had your signature notarized and witnessed, and also you have the agent who has signed the power of attorney as well. And you can have more than one agent. There's no limitation on the number of agents. I generally like to have 2 agents on a power of attorney because I draft a power of attorney that is very broad in the sense that it allows the agent to do virtually everything that I can do. And the reason why I do that is because I don't want to handcuff the agent. I don't want an agent to be able to, not to be able to do everything that I can do. For example, unless the power of attorney has a gift rider to it, then the agent will not be able to do any gifting. The agent will not be in the position to be able to transact assets and transfer assets so as to protect the assets for elder law planning purposes, Medicaid eligibility purposes, or for example, I want to do estate tax reduction techniques. I want to reduce the size of the principal's estate while the principal is disabled by making gifts. So drafting a power of attorney that is very broad in that sense is, in my opinion, probably the most important thing to do. Unfortunately, a lot of attorneys do not draft broad powers of attorney. They utilize and rely on the New York State statutory short form. Many instances, these are forms that they're getting from title companies or forms that they've created, but they are not broadly drafted. They're not modified for the needs of the individual client. For example, an individual that has a business may have different needs from an individual that doesn't have a business. If I'm a shareholder of a corporation, I may want certain language in my power of attorney that an individual that's not a shareholder of a corporation would want. So in the form that we utilize, there is what's called a modification section. In that modification section, you can basically modify the form of the power of attorney. You can actually enlarge it in many aspects, or if you wanted to, limit it, you could limit it in various aspects. But it all has to be done in the modification section with respect to anything that has nothing to do with gifting. So in this durable power of attorney, where I'm appointing either one person or two people or three people to act as my agent, I can fashion it and draft it in such a way as it's necessary for the needs of the individual, and then I can actually expand it with respect to making gifts. And the part about making gifts is critical. Why is it critical? Well, if I get sick, for example, let's say I'm struck with, God forbid, with COVID-19, and I'm in a hospital, on a ventilator, a respirator, and I'm out of commission for weeks and months. Well, how is my family going to continue to maintain their affairs, my affairs? How are they going to continue to pay my bills, transact in our stock and brokerage account, make decisions about transferring assets out of my name so that I may become eligible for Medicaid, or transfer assets out of my name to do tax planning? Without a properly drafted durable power of attorney, your family, your loved ones are going to be handcuffed. They're not going to be able to do the things that they really need to do to be able to protect your assets. They won't have at their fingertip a document that is, 15, 16, 17 pages long that spells out all the rights and authority they have to handle your affairs. So it is a very critical document. In my opinion, it's the most important document most of us will ever going to sign. As I said earlier, I like to have two agents on the power of attorney because in my opinion, that creates a system of checks and balances. Because the power of attorney that I prepare is drafted so broadly, and in particular has a very broad gift power in it, I definitely want to have the agent not to be in that position of sole authority. If you don't have somebody that you can pick, you don't have more than one person you can pick, obviously you have no choice but to pick that one person. But if there are multiple people that you can select, especially if you have children, let's say, for example, you're a single person and you have two children, what you want to do is you want to select the two children. If you only select one child, what happens? Then that one child has all this power and authority. They can then act without the permission and consent of the other person that's the agent on the power of attorney. So I like to draft broadly. I like to put in as many provisions as I can about what the agent can do. For example, I have very broad gifting language about the agent being able to transfer to themselves, to their siblings, to other family members. And I make it and draft it in such a way that it's unlimited authority. There's no limitation as to how much the agent can gift. Obviously, you want to select agents that you trust. You don't just want to, select somebody that you met. Maybe your mailman is not the best choice as your agent under the durable power of attorney. You want to be specific about the powers you want that agent to have, and you want your attorney, who is going to be preparing that power of attorney, to know all of the intricacies of your life, and in particular your business. What are the things that are unique about your business? What are the things that are unique about your life, your relationships, so that in drafting the power of attorney, they can take into consideration all of those different issues. Now, again, with my power of attorney, it's drafted so broadly that it really covers virtually every issue. In recent years, we've modified the power of attorney in many different ways so that if you're somebody that has a power of attorney that's more than 7, 8 years old, you probably want to update it because, as I've said, we have modified it significantly over the last 8 years. And I think that's a good piece of advice for all of your estate plans. If you have an estate plan and it's been more than 6, 7 years since you last looked at it or updated it, you definitely want to take a look at it now, and you want to make sure that it's current. I can't tell you how many times a client will come in and review their power of attorney. They'll review their will. They'll review all the documents they've signed and discover that they named people as executors, trustees, or made bequests for certain people that they no longer have a relationship with. They're no longer speaking to. And they completely forgot that they had named those individuals in their documents. So what I would like to say, it's important that you keep track of what you've done in your documents in the past and make sure that your documents are current. They express your current wishes and desires. You don't want to wait 15, 20 years. Since this COVID-19 outbreak, it's amazing how many times I've been contacted by a client who hasn't spoken to me, hasn't reached out in over 15 to 20 years, and they still think their documents are up to date. Well, in some respects, they may be up to date, but in others, they're not. 15, 20 years ago, for example, we were not including language about digital assets in our powers of attorney. We did not have language about what happens to your digital bank accounts and all the other digital assets you have, whether it may be photographs, etc., and all of your accounts. So what we've done is we've updated the document to make it current as to what people's needs are today. And that's the way you should view your estate planning documents, whether it's a power of attorney, your healthcare proxy, etc. Is it current? Does it really reflect my wishes as they are today? Okay, so just as a recap, durable general power of attorney with a broadly drafted modification section and a broadly drafted gift rider are critical. Again, I like to have more than one agent on my power of attorney. I think two is a great number. It creates a system of checks and balances. They have to act together. They must know what the other person is doing. There's no way for them to go and move all your bank accounts to themselves without the other agent knowing. So very important document. Second most important document, a healthcare proxy. What is a healthcare proxy? A healthcare proxy is a writing where it's actually the only legally recognized, other than a most form, where you can select somebody to make healthcare decisions for you. And the healthcare proxy is a document that really does not go into effect. It's an advance directive, but it does not go into effect until you no longer have the ability to make your own healthcare decisions. So you can have a healthcare proxy. You can name somebody as an agent. And in New York, you can only name one agent at a time. Many times I see homemade healthcare proxies and the individual has appointed two agents. That doesn't work. You cannot have co-agents in New York on a healthcare proxy. One agent at a time is what you must have. What does the healthcare proxy do? Well, it allows you to spell out what your wishes are as to medical treatment, end-of-life decisions, whether you want to be on a respirator, ventilator, whether you want to be tube-fed. These are the things that you can detail in the healthcare proxy. You can be as specific as you want in a healthcare proxy about your medical wishes. You can put in as much information as you want, but I caution you against doing that. I really don't recommend being very, very specific in the healthcare proxy. Why? Because the healthcare proxy under New York law says that my agent knows my wishes unless otherwise stated herein. So you don't have to be detailed in the healthcare proxy. You can tell your agent what your wishes are. You can tell them whether you want nasogastric tubal feeding. You can tell them the circumstances where you want to be on a ventilator or a respirator. You can spell that out to them orally. You don't have to spell it out verbally on the document. The reason I don't like spelling it out verbally on the document is that I may miss, as a client, a type of way of keeping you alive and not refer to it. So I may say no nasogastric tubal feeding, but I may not refer to any other way of keeping you alive. And that can create issues and conflicts at the time the agent under the healthcare proxy has to make a decision. So if the agent has to make a decision in a hospital setting and now there's conflicting information about my wishes in the healthcare proxy, that can create issues. And we really don't want that to happen. So my opinion, it's best to leave the healthcare proxy as vague as possible. Select somebody that you have a great deal of confidence in and trust in so that they can make those decisions for you. And again, they can make virtually every decision that you could about medical treatment, medical care, and end of life decisions by utilizing the healthcare proxy. Okay? So, and again, it does not go into effect until you're no longer able to make decisions. So as long as you can make decisions, that healthcare proxy is going to continue to work, not be utilized, and you'll be able to make your own medical decisions. And then as an advance directive, it'll kick in when you can no longer make those medical decisions yourself. So when you can't make the decisions, your healthcare agent can make them for you. And that could be, again, in a hospital setting, any medical setting, nursing home, etc. And it's a very broad document in that it really covers all of your personal affairs. So if you have a power of attorney that covers your financial decision making, and you have a healthcare proxy that covers your medical decision making, those two documents in and of themselves are normally sufficient to avoid needing a guardianship for you if they're sufficiently drafted and well drafted. With the power of attorney, many times it's not well drafted. And because it's not well drafted, we find ourselves having to go to court and have a guardian appointed for the individual that's incapacitated because their power of attorney just didn't cover it. There's not a gift writer, there's not sufficient gifting authority, there's not sufficient authority to do the things that are important to be done for that individual under the circumstances. Okay, so now we have the power of attorney, we have the healthcare proxy. Another document that kind of works hand in hand with the healthcare proxy is a living will. A living will is not statutorily recognized in New York. However, it has been used by tradition and by practice in New York for at least 35, 40 years. And it kind of works with the healthcare proxy like a belt and suspenders approach. The healthcare proxy allows you to select somebody to make healthcare decisions for you when you're no longer able to make those decisions. And then the living will says to the world, I want you to know that if I'm brain dead, comatose, with no hope of recovery, I don't want to be kept alive by extraordinary measures. So it's a statement of your intent not to be kept alive by extraordinary measures. And that's, what makes it a valuable document. So even though you may have a healthcare proxy and you've expressed your desires and your wishes to your healthcare agent, it always helps to have that living will there as well. The way I've always explained it to clients is, let's say, for example, your healthcare agent is dealing with the doctors at the hospital about making end-of-life decisions, and they're getting pushback, and they're getting difficulty with the hospital recognizing the healthcare agent's decision about ending life. Well, that healthcare agent, if they have that living will, pulls out the living will and says to the hospital and the doctors and the committee, look, here's a living will for Mr. Smith. Mr. Smith made it clear, signed and witnessed, that they did not want to be kept alive by extraordinary measures. And that's a document that will have some sway. It'll have some import on the ability of your healthcare agent to make those decisions. So very important document. In terms of financial and medical decision making, I consider them to be the triumvirate of financial and health decisions: the healthcare proxy, the living will, and the durable general power of attorney. Now, there's another document that is very helpful in the decision-making realm, and it's a document that allows the agent to have access to your medical records. Now, in a healthcare proxy that's done in New York, a current one that's been done over the last 15 years, there is what's called a HIPAA authorization. HIPAA is the acronym for the Health Insurance and Portability Act. I think it was 2005. So basically, the HIPAA authorization is the authorization that you sign when you go to a doctor's office, saying that your documents, your medical records, are to be held confidentially and privately. But if you give a HIPAA authorization to an agent, that agent now has the ability to access your medical and hospital records. They have the ability to go to the doctor's office with the HIPAA authorization and say to the doctor, please give me Anthony Ania's medical records. And you can actually expand that authorization to include drug addiction records, alcohol addiction, and psychiatric records as well. So it's a very important document. We do it as part of our standard package. Every time we do an estate plan, that estate plan includes a durable general power of attorney, a living will, a healthcare proxy, and a HIPAA authorization. Very important documents. They're documents that you really need to keep as part of your file, and something that you should always have on hand during a crisis like we're undergoing now. Right now, everybody should know where their healthcare proxy is, where their power of attorney is, and where their living will and HIPAA authorization are. You really want to know where they are at this time in particular. Obviously, it's always good to know where they are and to have them, close by in case you need them. But now with this crisis and people going to the hospital, people having to decide whether to go on a ventilator, respirator, etc., they're even more important. They're critical in the sense of being able to handle your affairs and your medical decision making. Okay, so those are advanced directives that we just discussed. All of them are advanced directives. What else should you have? What are the other documents that you should have as part of your arsenal of good planning documents? Well, a last will and testament. What is a last will and testament? People always get confused about what a will does and what assets it controls. And what most people don't understand about a last will is that a last will only controls assets that are in your name alone on date of death. A last will and testament does not control assets that are in a joint bank account, that have named beneficiaries on it. For example, your IRA, your 401k, they generally have named beneficiaries and named alternate. If you're married, you have your spouse, and then you have your children as the alternate beneficiaries. That's important. Everybody should check the beneficiary designations on their IRAs, their life insurance policies, annuities, Roth IRAs. Anything that has a named beneficiary on it is not controlled by a last will and testament, right? These things are not controlled by your will because your will only controls assets in your name alone, nothing in a joint bank account. A will is a writing. It's a writing where you can spell out what your wishes are as to the disposition of your assets at the time of your demise. So in a last will and testament, I can be very specific. I could say, I give my collection of baseball caps to my son Michael. I give my collection of ties to my son Michael. And you can be very specific about who you want to give certain things to. You can also decide in your last will and testament, whether or not you want to provide for somebody. You may make decisions not to make provisions for certain people. But in a will, it gives you the ability to state exactly who you want to receive your estate when you die, and it also allows you to designate who are the individuals that are going to handle your estate and your affairs when you pass away. Very important. Why? Because if you die and you do not have assets in your name, if you die and you have assets in your name alone and you don't have a will, then what happens? Then the laws of intestacy apply to who's going to get those assets. So depending on whether you're survived by a spouse and children, the statute determines who's going to get what, and virtually anybody can apply to then become the administrator of your estate. And that's not something you really want. You want to be able to dictate who is going to receive your assets upon your demise, what percentages they're going to get, and you want to be able to specify who is going to be the executor of your will. And remember, in a will, you can also create a trust. So many instances for our clients, the parents will say, well, my children are adults, they're 40, 45, 50 years of age. When I die, I want their share to go to them outright. However, if they don't survive me, I want their share to go to their children. And if their children are under a certain age, let's say they're under the age of 30, I don't want them to get that share outright. I want that share to stay in trust for my grandchildren, and I want X, Y, and Z to manage that money on behalf of my grandchildren and be able to use that money for their education, health, maintenance, and support. And once they get to the age of 30 or 35, whatever age you want to may select, then those children will get their share outright. So in a last will and testament, you can describe who's going to get what percentages they're going to get, or what dollar amounts they're going to get, and you can describe whether it goes to them outright or in a trust for a certain period of time. In a last will and testament, if you have a special needs child, you can also create a special needs trust for a special needs child. Generally, what we try to do is to create a separate vehicle for that, what's called a third-party special needs trust, but it can be done in a will as well. So having a will is very, very important. As I said, even though it does not impact assets that have named beneficiaries or assets that are in joint name, it still does a great deal of good to have a last will and testament. You don't want to pass away with assets in your name alone and then have the courts decide who's going to be the administrator of your estate, and additionally, the law specifically decide who gets what. You want to be able to make that decision. You don't want that decision-making authority to be taken away from you. So it's a very important document. A last will and testament does have some drawbacks if you die and you have assets in your name. The one drawback of a will is that it has to go through the probate process. So a last will and testament, in order to be valid, has to be admitted by the probate court or the surrogate's court in the county where you reside. So a lot of times people say to me, I have a will, and my dad died, and here's his will, and I'm going to make the transfers as per the will. Well, that's not the way it really works. The will is not valid. It's not a valid legal document unless it's legally recognized by the court. And in order to be legally recognized by the court, it has to go through the probate system. It has to go through the process of probate, which is offering the original will to the court, filing a probate petition, giving notice to all parties that are interested in your estate, all distributees, people that would inherit, but for the fact that you have a will. And in this probate process is sometimes where complications arise. That's where you could potentially have a will contest. Or, for example, let's say I passed away, and at the time I passed away, I had a child or a spouse that was incapacitated or disabled. Well, under those circumstances, the court would appoint a guardian ad litem for that disabled spouse or child to make sure that their interests in the probate proceeding are protected. So having a guardian ad litem could make things a little bit more expensive and could slow down the probate process. If you said to me, what are the drawbacks of probate? I think there are really three major drawbacks of probate. One is the delays. The whole probate process, even in a court like Westchester Surrogates, which is a very efficient court, still could take anywhere from 9 months to a year from beginning to end. The legal fees and the filing fees for the probate process can be expensive depending on the size of the estate and the complexity of the estate. And I think the third drawback is this possibility of there being a challenge or a will contest. I think that is a significant drawback. Remember, a document that's gone through probate is a public document. It's on file with the court. Anybody literally can go and look at the file and look at your last will and see how much in probate assets you had. It really lacks that sense of privacy that most individuals want today. So there are drawbacks with it, but it's still a document that's important to have. If you want to have a planning document, which I think is much better than a last will and testament, and it's a planning document that I've been using for decades, I recommend a revocable living trust. What is a revocable living trust? A revocable living trust is a writing. It's a contract, and it's a contract between the creator of the trust, the grantor, and the trustee. In New York, you can be the creator of a revocable living trust, and you can be the sole trustee, or you can be a co-trustee. And as long as there are alternate beneficiaries, you can be the sole trustee of a revocable trust. So the way I like to describe a revocable trust is it's like a canister or like a coffee cup. And I'll give you an example. This is my firm coffee cup, and it's, as you can see, it's filled with pens. So what I like to do is to use the visual of the revocable living trust being the coffee cup, and the pens as being the contents, the assets that are used to fund the revocable trust. And these assets, these contents, can be your bank accounts, your brokerage accounts, your real estate, your house, your vacation home. And once the assets are titled in the name of the revocable living trust, then what happens is they're owned by the trust. They're assets that are owned by the revocable living trust. They're part of the trust corpus, and then they're under control of the trustee. And a revocable trust, as the title describes, can be revoked, can be amended, can be modified. Think of it as a piece of luggage that goes with you throughout your lifetime. And if you gather assets and you own more assets, well, you keep titling them in the name of the revocable living trust. So as you're going through life, you have this pot of assets that are in this canister called the revocable trust. That canister is under the control of the trustee. Well, if you're the sole trustee, that means you have full control over the assets in the trust. You have 100% control. They're your assets. For tax purposes, they belong to you. You pay income taxes on them like you would pay income taxes on any income that's being generated. For all intents and purposes, you are the revocable living trust. And in fact, if you're the beneficiary of the trust, you don't even have to get a federal ID number for the trust. It can use your Social Security number. During your lifetime, you own, you control, you manage the assets in the trust. The moment you die, the trust comes to an end, it terminates, and now the trust specifies who's going to get the assets that belong to the trust. It spells out where the assets are going to go, to whom, and it can also spell out who the individuals are going to be that are going to manage those trust assets once you've passed away. So the trust appoints you as the sole trustee, or if you're married, you and your wife, and then when both of you die, if you want your children to be the alternate trustees, or you want some other third party, a family member, an advisor, whatever the case may be, then you name that individual to be the alternate trustee. Then what happens? The trust ends, and the alternate trustees make sure that all the trust assets are in the trust, pay all the bills, and now they're in a position to make the distribution of the trust assets to the trust beneficiaries. But there's no probate. We don't have to go to court. There's no probate process. There's no filing with the court. The trustees just distribute the assets to the named beneficiaries. They'll get what's called receipt and releases and refunding agreements from the beneficiaries so that the beneficiaries acknowledge that they've received everything that they're entitled to under the terms of the trust. Great vehicle, fantastic planning tool. Started off in California maybe 35, 40 years ago, if not longer. People in California were very tired of going through the probate process and the expense and delays of probate. My recollection used to be that lawyers in California would get paid a statutory fee based on the size of the probate estate. I'm not sure if that's the law now, but that used to be the law, and it could be quite expensive to go through the probate process. So avoiding probate became a very popular tool in California. It's become an even greater popular tool in Florida, and now in New York. It's finally starting to get the recognition and due that it deserves. In my mind, it's very valuable, A, because avoiding probate is valuable. And the other thing is, if I'm doing, and I'm worried about, Medicaid planning and Medicaid protection, it does have a benefit in a limited circumstance in that if I die and the assets in the probate trust have not been previously subject to any claims in the revocable trust have not been previously subject to any claims by Medicaid. The moment I die, that revocable trust terminates, becomes irrevocable, and in New York, Medicaid does not have claims on non-probate assets. Now, it is not the way of protecting assets for purposes of Medicaid eligibility. It's not a Medicaid asset protection tool. However, in certain limited circumstances, it does have advantages. Okay, so the revocable trust, when we do a revocable trust, we always do a will. It's called a pour-over will. The will basically says, I give everything I have that's in my name alone, in the event you die with something in your name alone, to my revocable trust. And then it says, God forbid, I don't have a revocable trust anymore. I terminated it. I want it to go as follows. So we always do a will with a revocable living trust. It's called a pour-over will. Okay? Finally, the final document I'm going to spend a little time talking about, and the planning I'm going to talk about, is elder law planning and asset protection planning. For most Americans, estate taxes are no longer a major issue. Why? Well, because the federal estate tax credit right now is $11.58 million per person. So a husband and wife can shelter almost $23 million from estate taxes. That law is going to be in effect until December 31st, 2025, unless it's extended by Congress. So unless there's a change in the law between now and December 31st, 2025, the credit is going to be $11.58 million per person with some adjustments for inflation. So right now, husband and wife, $23 million, federal estate and gift tax exclusion. Now, remember, this is an important fact. This exclusion is not only an estate tax exclusion. This amount is also a gift tax exclusion. Most people believe that all they can give away is $15,000 per person per year. That's not true. You can give away significantly more. In fact, you can make gifts up to $11.58 million during your lifetime. So this credit is not only an estate tax credit, it is also a gift tax credit. The one advantage to this law under federal law that we don't have in New York is the concept of portability. Under federal law, it really makes no difference how much the spouses have, whether the husband has $11 million in his name or the wife has 11 million. Basically, the husband and wife can use the $23 million. The amount is portable between spouses. So it's really irrelevant as to how much each person has. Okay? So there's this concept of portability. Again, most people are not affected by this. They don't have estates this large. The population that has an $11 million estate is less than 1%. This is a significantly smaller amount. But it's important to know this. New York's estate tax credit is $5.85 million per person. Okay? So again, husband and wife can shelter over $11 million for New York estate taxes. For a lot of higher net worth individuals, the New York estate tax credit does pose some problems. And the big problem that it poses is that there's something called an estate tax cliff. What does that mean? In New York, if you have more than 5% greater than $5.85 million in your estate, and you don't have a spouse to leave the assets to, then what's going to happen, that estate is going to pass, that estate will pass subject to potential estate taxes. That estate tax could be significant because New York has an estate tax cliff. So in New York, if you have a $6.2 million estate, for example, your estate is 5% greater than 5.85. So let's say for argument purposes, I die this year, I have no spouse, I just have children, and I have a $7 million estate. Under New York law, I've gone over the cliff. My estate's 5% greater than 5.85 million, and now my estate's going to be subject to an estate tax of 16% on the entire amount. So it is a significant estate tax in New York, and in New York, unlike federal law, there is no concept of portability. In order to take advantage of the estate tax credit in New York, you must have assets in your name alone to take advantage of the credit. Okay? Just a little side road just to give you an idea about estate taxes. So estate taxes, generally not a priority for the vast majority of Americans. What is a priority? The cost of long-term care and how do you pay for that long-term care. So most Americans don't have long-term care insurance. Is it advisable to have long-term care insurance? Absolutely. Today, there are great products out there that are available to both individuals purely for long-term care purposes, as well as what they call hybrid policies that are combinations of life insurance and long-term care policies. So something that if you're in good health and haven't gotten to age 50 or above yet, you should really consider looking into long-term care insurance. It's a very worthy thing to have. And what does it do? Well, it allows you to have insurance coverage if you need home care or if you need long-term care in a nursing home. Now, for most Americans who don't have long-term care insurance, the only way that they can pay for the care at home or care in a nursing home is A, pay for it privately, which can be very expensive and very devastating to their life savings. I don't know if most of you realize it. The cost of a nursing home in Westchester County is anywhere from $400 a day to $500 a day. It's in excess of $15,000 a month. The cost of home care in Westchester County could be anywhere from $6,000 to $8,000 a month. So if you don't have long-term care insurance and you don't have vast amount of savings to be able to pay for those expenses, what can you do? Well, the program of last resort is Medicaid, and Medicaid is not Medicare. Medicaid is what's called a means-tested entitlement program. In order to get Medicaid, you have to meet the financial test, and the financial test is very low. So for most of us who are in the middle class, in order to be able to protect assets, what we need to do is take proactive advanced planning steps. And what is that? Well, the step that most seniors take and most people take is to create what's called an irrevocable Medicaid asset protection trust. It's an irrevocable trust, just like it's like the revocable trust in the sense that you transfer assets to the pot, and those assets can be your house, can be your savings, not your IRA. IRAs are not transferred to an irrevocable trust for Medicaid planning purposes. For Medicaid planning purposes, IRAs, as long as you're taking your minimum distribution, are protected. Medicaid does not have claims against IRAs so long as they have named beneficiaries and named alternate beneficiaries. In New York, Medicaid only has claims against probate assets. So if, for example, you don't have a named beneficiary on your IRA, or you only had one named beneficiary and you didn't name an alternate, well, then when you die, that beneficiary is not alive, that money is going to go to your estate, and if you've been getting Medicaid benefits, Medicaid will have a claim against that estate. So very important to check your IRAs, your life insurance, to make sure that they're named beneficiaries and named alternate beneficiaries. Okay? Now, being proactive. You create this Medicaid Asset Protection Trust. Most seniors, I would say the vast majority, appoint their children to be the trustees. If they don't have children, they appoint either other loved ones, nieces, nephews, close family members, siblings, etc. The trust is irrevocable. What does that mean? That means you cannot revoke the trust. You cannot amend the trust. However, there are things that you can do. There are powers that you have that are very significant and decisive powers. For example, you can change who the trustees are of the Medicaid Asset Protection Trust. And you can also change your mind as to who the ultimate beneficiaries are. If you reserve something called a limited power of appointment, you can change your mind as to who will be the ultimate beneficiaries. And this is a very strong power because the trustees, presumably the children, will know that if they're not doing what you expect them to do vis-a-vis the trust, then you have the ability to change your mind as to who's going to be the trustee and even who's going to be the ultimate beneficiary. So to give you an example how the trust works, let's say, for example, you're a typical middle-class Westchester resident. You have a house and $500,000 of savings, or $400,000 of savings, non-IRA. I guess I said earlier, your IRA is already protected. What you would do is you would take your house and you would deed it to the irrevocable trust, and you would take an amount of your savings that you're comfortable giving up control over and placing it in the irrevocable trust. If you wanted to, you can get all the income that the savings generate, or you can say, I leave it to the trustees in their discretion to give me the income. Generally, I don't like to say that you must get the income, because if I say that in the trust and then one day you need Medicaid home care or Medicaid nursing home, Medicaid will count that income as your income. So I generally like to say the trustees have the ability to give the income to the grantors at their discretion, or no income to the grantor and no principal to the trust, to the grantor. So generally in the trust, there is clear that whatever you put in the trust cannot go back to you, right? There's no invasion of principle for the creator of the trust. When you transfer assets to this irrevocable trust, right, in particular your house, you have the right to live in the house for the rest of your life. You continue paying all your bills just like you're paying now. You get the STAR exemption, any senior citizens exemptions, any veterans exemption, all tax exemptions that you're entitled to, you continue to get. If the house is sold during your lifetime, you're still eligible for the personal residence exclusion. What does that mean? Well, you can exclude, if you're single, up to $250,000 from capital gains, And if you're married, you can exclude up to $500,000 from capital gains. So all the tax advantages that you have continue with you, even though you've transferred your house into the irrevocable trust. You have the right to live in the house for the rest of your life. Nobody can sell it or rent it without your permission. You continue paying all your bills, just like you're paying now. The only bill that's going to change is the bill for the insurance on the house. Rather than that bill being in your name, that bill is going to have to be in the name of the trust. So there's virtually no change in your lifestyle. There's no change in anything. You're living in the house. You're paying all your bills. Once you've transferred the house to the trust and perhaps some of your savings to the trust, you've now disqualified yourself for nursing home Medicaid for 5 years. You have created the 5-year look back that everybody's heard about. Well, that's what you want to do. You want to create the 5-year look back for nursing home Medicaid when you don't need nursing home Medicaid. The other beauty of doing this and creating this 5-year look back for nursing home Medicaid, is that it does not create a 5-year look back. There's any look back for home care Medicaid. So even though you've transferred assets into the trust, you're not disqualifying yourself for home care Medicaid. So if you need home care Medicaid, that is still an available option to you. New York is very generous with its Medicaid home care program. I don't know how long that's going to continue for, but that's something that's in effect now. There is no look back period for Medicaid home care. And I must be honest with you, over the last 5 to 10 years, the vast majority of Westchester residents, New Yorkers, want to remain at home and get care at home. There is no great flight to nursing homes. People want to stay and age in place. They want to live in their homes, and they want to die peacefully in their homes or in a hospital, but they don't want to go to a nursing home. The number of people going to nursing homes, I think, has been significantly reduced over the years. There are other forms of homes, assisted living, independent living, and that's all kind of impacted people going to a nursing home. So the nursing home is not the answer in the first step. It's usually staying at home. It's usually the last resort now is where you can't stay at home anymore. You can't be taken care of at home, where there's consideration of going to a nursing home. But by doing this Medicaid Asset Protection Trust and by transferring your assets, your life savings, to the trust at a time when you don't need Medicaid nursing home, starting that 5-year clock running, you're going to be ahead of the game. You're giving yourself a chance of protecting the assets. And that's what most middle-class Americans want to do. Believe it or not, most middle-class Americans really are concerned about their legacy. They don't want to lose their life savings. They don't want their life savings to be completely used on their long-term care expenses. Their goal and their objective is to preserve their legacy, their life savings for the next generation, whether it be their children, their grandchildren, etc. I had a couple sitting in this room last week, basically, or the week before, telling me that all they wanted to make sure was that when they died, that there'd be enough money for their grandchildren to be able to go to college so that they would not be, overcome by student loans and debts. Creating this Medicaid Asset Protection Trust allows you that peace of mind. It allows you to know that you're taking those steps to be able to protect your assets and your life savings if you need long-term care in the future. And that's a big concern. Most Americans are concerned about the cost of long-term care because it's just exorbitant. As I mentioned before, anywhere from $450 a day to $500 a day is not out of the ordinary. There are nursing homes in New York City, Long Island, that are already charging probably close to $600-700 a day. Unless you're very wealthy or have long-term care insurance, most individuals cannot sustain that for any significant lengthy period of time, especially if you have a husband and wife and they're both seniors and now you're facing the possibility that both of you over time could spend significant amounts of time in a nursing home. You can see how easily it would be to lose hundreds and hundreds of thousands of dollars to the cost of long-term care. Okay, so I don't see any questions uh, on the on the screen here. So I guess I hopefully I've answered a lot of your questions about long-term care planning. Uh, I wish all of you the best. I think in these times, in these difficult times, I think it's very important that people stay focused, on their healths, doing what the government is telling us to do. I think we should respect the government's wishes. I think if we can continue to support our local businesses and restaurants, we should do that. We really need to support our local restaurants. I'm going to give what they call a shout out, I guess, to the restaurants in my area. Mama Rosa's here in Somers, to my friends Fortunato, Sisto, and the entire crew, and Eddie at Mama Rosa's, great people. Please continue to support Mama Rosa in White Plains, La Boca, Scarsdale, Moscato's, Aquario in Silver Lake and West Harrison. Please support your local restaurants, your stores. Do whatever you can. A lot of good, hardworking people are really feeling the pinch right now. And if you can continue to support them, I'm sure they're going to be very happy. Thanks a lot. And it was really a pleasure helping to address you. At Aeneas Scanlon and Sirignano, we're available for you. Everybody's working remotely. Everybody's working. If you need a consultation, if you want to speak to me, feel free to call and we'll get back to you right away. Thanks a lot and have a great afternoon. Bye-bye.